thank you for attending these virtual discussions today on the Energy Charter Treaty, modernization process, and the expected outcome and the potential way forwards. So my name is Amandine Vandenberg. I'm a Brussels-based lawyer at Planet Earth. We are a global environmental law charity, and I work on environment, trade, and investment-related issues. An important part of my work focuses on advocating for reforms in the international investment law regime to bring it in line with environmental and climate objectives. And I will be your moderator today. After a short introduction and some housekeeping rules, I will kick off the discussions with some reflections around the DCT modernization process that actually have led us to organize today's discussions with our legal experts. So we'll hear from our experts. They are all experts in the field of investment law. They will discuss what are the alternative routes if the modernization process fails, what are the risks and the limitations of each options. Our speakers will also discuss the potential implications of upcoming Court of Justice ruling for the modernization process. So we will have about 1 hour of presentation by our experts, and then we will have up to an hour for an open discussion. We may not need the full hour, but we really wanted to make sure that we have sufficient time for you to ask all the questions that you may still have, to express your views, comment on the speakers' presentations, and exchange them among yourselves. So today I am joined by Professor Nicolas Angelet from the Free University of Brussels. Nicolas is specialized in public international law. His areas of expertise cover all aspects of public international law, including the law of treaties and investment law. Nicolas is a member of the Brussels Bar, and he also sits as an arbitrator. We also have Nathalie Bernasconi from the IISD. Nathalie is a senior international lawyer, and she's been working on reforming the international investment law regime for many years. And Nathalie is the head of the Economic Law and Policy Program at IISD, and she's also the executive director of IISD Europe. We have Professor Matthew Appold from the University of Luxembourg. Matthew's area of expertise also includes international law, international dispute settlements, and international human rights law. And Matthew also practices as a barrister in the UK. And our last speaker, Karen Cross from the University of Berlin, unfortunately had to cancel his participation in the last minutes for personal reasons, but he is passing on to me and to you his apologies for not making it today. So I will make a very short kickoff presentations because I wanted to share, as I said, very briefly the reflections that have led us to organize this meeting. And these can be really structured around three main questions. The first one is what are the key issues that need to be addressed with DCT? The second one is how is the EU trying to address DCT shortcomings through the modernization process? And thirdly, is the EU going to succeed in addressing these issues through the modernization process? On the first questions, what are the key issues that needs to be addressed? You may be very well familiar with the issues that civil society has brought into the light over the past years. DCT is the most frequently invoked treaty-based ISDS mechanism. It has led to a number of investment arbitration between EU investors and EU countries. It has involved a huge amount of compensation. It created also demonstrable chilling effects on government actions in certain instances. It's also widely acknowledged that DCT is very outdated and obsolete investment treaties from the 90s, both from an investment and a climate perspective. We've had also recent rulings from the Court of Justice of the European Union that indicated that the investor-state disputes settlement mechanism under DCT may not be applicable in intra-EU disputes. The ECT investment standards are also not likely to be in line with the modern standards that the EU is promoting in its new agreements. And that was also highlighted by the Court of Justice in its opinion 117. And then secondly, the concurrency also with the objectives of the Paris agreements and the sustainable development goals. We've seen also recent threats and actual claims against environmental and climate measures, notably to phase out, measures of coal-fired energy production in the Netherlands. So that has confirmed the fears of civil society that the ECT can be an obstacle to climate action. And on the second question, so how is the EU actually trying to address these shortcomings through the modernization process? Well, the Commission has definitely seized the opportunity of this process to address these shortcomings, and they formulated two main objectives, as you know. The first one is to revise the ECT investment protections provisions, and in particular, also reforming the IISD mechanism. And the second one is to better reflect the climate change and energy transition goals. But on aligning investment standards, despite the fact that from our perspective, the new EU investment standards are still imperfect, the main issue is that the ISDS provision is simply not open to a revision in this process that's been off the table from the beginning. And so the EU is relying on the reforms that are happening at the UN level, where they are trying to build their multilateral investment courts, but these outcomes are also very uncertain. And on the attempts to make the ECT Paris compatible, the main proposal from the EU in this regard concerns the phasing out of the investment protection for fossil fuel, but it's lacking ambitions, because under this proposal, most of the fossil fuel infrastructure are going to be, they're going to continue to be protected until the mid 2030s, while the legislation on phasing out coal, gas, and oil actually needs to be developed and implemented now. So we have a very short window of opportunity to address climate change, and we've been waiting for too long for governments to take action. And so currently the EU proposal is lacking some ambitions in this regard. And then the third aspect is the EU going to address, is the EU going to succeed in addressing this issue and with their proposals? So taking stock really of the last negotiation round and the public reports that have been made available, while progress are very slow, there seems to be little appetite from non-EU countries to revise the relevant investment provisions in accordance with EU proposals. There are indeed widely divergent views on this. And on climate-related proposal, again, there seems to be little support from other non-EU countries. So there is little chance that we get the necessary bold reforms that are needed out of this process, and especially within a reasonable time frame. So instead, we may get stuck into negotiation for several years, and in the end remain with the text unchanged, with outdated investment provision, old-style ISDS mechanism, and fossil fuel investment being protected. And thus we may miss the opportunity of removing such an obstacle to a swift climate action. So to conclude, that's what has actually led us to organize this discussion today, is that we want to assess all the options that are actually available besides this modernization process, and to better understand also why the modernization process is very difficult, because of the unanimity rule that applies to any amendment of the ECT. So that actually brings me to ask questions directly to Professor Nicolas Angelet. So Nicolas, can you provide a broad overview of all the options that are actually available under international law to change the ECT if the modernization failed to lead to meaningful reform?
Thank you, Amandine. And thank you also for inviting me here. I'm very happy to participate in this discussion. What I will not address is the substantive issues of how, if and how the ECT should be changed, my task is much more limited. I've been asked to discuss whether there is room for changing the ECT within a limited circle, so inter-C as between some of the current parties only. So before doing that, I would like to address a slightly theoretical issue if we move to the next slide. And since I cannot handle the slides, perhaps if I say yes, please regard this as a request to move to the next slide. The first thing I wanted to stress is this, in particular in international law in general, but in international investment law in particular, much emphasis is always placed on stability and legal certainty, which is self-evident because international law is largely about stability in international relations, and obviously, until now, the focus of international investment law was on legal certainty for the investors. Now, my first point as an academic, but also as a practitioner, is that we must really take into account that law, of course, is about stability, but it is also about organizing change, and it is about legal certainty, but it is also, and perhaps even more so, about risk management. Thank you. Next slide. So, and to illustrate this, I have chosen this quote from a very famous professor of international law and legal theory from Yale Law School, but also a famous investment arbitrator, Michael Reisman. And what he says is that law, obviously, we know that implies that it is concerned only with securing fidelity to certain agreements made in the past, but in fact, law is concerned only with the future. Its concern is to devise a strategy that will increase the likelihood of the eventuation of desired events. What the lawyer does is invent alternative strategies, and that is what I have been asked to do today. So if we move to the next slide, we have a traditional, very standard risk assessment chart. And listening to Mrs. van den Berg, you see that we are now with the ECT and climate change issues. Mrs. van den Berg would say we are in the right top corner of the chart in the deep red situation, where we have a high likelihood of the ECT giving rise to claims in the context of energy conversion, with the consequence, which is very important, that, for example, this will lead to further locking in human and financial resources into fossil fuel industry. It will perpetuate dependence on fossil fuel, etc. That is the working hypothesis for me. And as you can see, if we were to adapt the substantive rules of the ECT, probably we would be able to move to the left in the sense that we would be able to manage the consequences of cases being brought. On the other hand, if we want to reduce the reduce the likelihood of cases being brought, of the ECT being used to hamper climate change policies, then we can rapidly move into the green. Why am I saying this? We will perhaps not reach absolute legal certainty, but we can move away from the deep red in the right top corner, and that, from a legal perspective, is what matters. So if we move to the next slide, perhaps we will have less legal certainty in some instances, but we can altogether lower the risk of facing arbitral proceedings, of states having to pay damages awards. That is one issue. So we have to balance legal certainty with the risk of facing arbitral proceedings and condemnations by arbitral tribunals. That is the state perspective. And then another issue is that one also and always has to carefully determine, delineate, and consider the precedential value of what we will be doing, because what we do today might be done by others tomorrow in different contexts where that would be a rather negative outcome. So if we move to the next slide, now we move to real legal issues. What do we have as techniques for change and risk management? First, termination and withdrawal. That will be discussed by Nathalie Bernasconi later on. We have amendment and modification, how to change the treaty. That will be for me. And we also have interpretation, which, that is one of my main points, is something that should be used in combination with amendment and modification. Next slide. So the first issue is, what about amendment and modification? Mrs. van den Berg just said that the amendment of the ECT is a difficult objective because of the number of states required that must be participate in the operation. Amendment is governed by Article 40 of the Vienna Convention on the Law of Treaties, and it is essentially concerned with changes made between all the parties to the treaty. At least that is the purpose. All the parties are invited to participate in the amending treaty, and the original treaty will remain applicable in the relations with parties who do not enter the amended treaty. Next slide. We move from amendment to modification. Modification is a change of the treaty between some of its original parties only. And here we see that the regime under Article 41 of the Vienna Convention is totally different. Changes can be made between certain parties only, either if it is expressly permitted by the treaty, by the ECT, or it is not prohibited, and under further conditions that the rights or obligations of the other parties are not affected, and the change is not incompatible with, I quote, the effective execution of the object and purpose of the treaty as a whole. Next slide. Now the question is, does the ECT prohibit modification? That is a change inter se between some of its parties. Some authors argue that it does, because there is a provision, Article 42, which provides for numbers and a high threshold for what? For amendments. Article 42 is concerned with amendments, not with modifications. And the fact that there are conditions in terms of participation for the amendment process does not stand in the way of modification. Why not? Because modification must meet additional different conditions, those that I mentioned, those that I will discuss, which are substantive conditions. It's not about the number of participants, but it is about the compatibility of the new treaty with the older one. So, first point, Article 42 does not preclude modification. Article 16 is often mentioned. Article 16 of the ECT provides that in case of prior or subsequent agreements on the same subject matter, the most advantageous regime to the investor will prevail. And here again, many people would say, look, we have Article 16, which provides that the most advantageous regime to the investor must prevail, where we have two treaties. So this implies that we cannot enter into a separate treaty between some of the parties only that would provide lesser protection to the investor. That is, again, in my view, not true. Article 16 is concerned with successive treaties, and that is governed by Article 30 of the Vienna Convention on the Law of Treaties. And it is specifically, typically, concerned with a situation where two treaties happen to coexist. And it was never the intention of the contracting states to replace one treaty with the other, which is typically the situation of the ECT that coexists with bilateral investment treaties. And no one intended to replace the ECT with a BIT or replace a BIT with the ECT. They just happen to coexist. Now, that regime of Article 30 is expressly without prejudice to Article 41 of the Vienna Convention, so it is without prejudice to the modification process. And that is why in case of modification, it is the intent of the parties to replace the former treaty with the new one, and it is the sovereign intent of the parties, of the states, that prevails. So Article 16 is no obstacle to modification. Next slide. The last point, provisionally at least, is Article 46 of the ECT. No reservations can be made to the ECT. And then again, the argument goes, if one cannot make any reservations, then one cannot change the treaty between some of the parties only. That again is untrue. Why? Because there may be two distinct reasons why a treaty prohibits reservations. A first instance, which is the case of human rights treaties, is that the treaty qualifies as a legislative treaty, meaning that it purports to enact a regime that will be uniformly applicable to all the contracting parties. In that case, if the reservation is prohibited because the treaty is legislative in nature, then modification is also prohibited. But there is another hypothesis. In some instances, reservations are prohibited because the treaty is a package deal. For example, I'm not an expert on the ECT, but for example, the Russian Federation would have agreed to participate in the treaty because it was interested in the provisions on transport, and it was willing in exchange to accept the provisions on investment protection that were in the interest of Western European states, or vice versa, that doesn't matter. In this case, we have a tit for tat. One state is interested in Chapter 1, the other state is interested in Chapter 2, and they reach a package deal, meaning if you accept transport, I will accept investment protection. And then, of course, reservations are prohibited because you can't opt out of the tit for tat. But the difference is that in such a case, the reservation does not necessarily prohibit modification of the treaty. If we now modify the treaty between, say, Belgium and the Netherlands and France and Luxembourg, that is a modification, which does not necessarily affect the package deal that was entered into, that was reached with Russia. The tit for tat between those participating in the new treaty and those who remain with the older one is unaffected. Therefore, it follows that the fact that reservations are prohibited, again, is no evidence for the fact that no modification inter se of the treaty can be pursued. And the ECT is, in effect, a bundle of bilateral relations, and it was achieved really through a package deal, as I mentioned. And therefore, the fact that it prohibits reservations does not evidence that it stands in the way of modification. Next slide. Then the further conditions, I don't want to become too technical, are that the amendment may not be otherwise incompatible with the ECT. I shall be brief here. It is important to understand that the ECT, if a change inter se is made, leaves the rights and obligations of the other parties unaffected. The ECT is not a human rights treaty. It is built on reciprocal undertakings, which are not erga omnes. It is a bundle of bilateral relations, and also abolishing protection between a small group of states or modifying protection does not, as such, affect investment protection for third states. If Belgium and the Netherlands modify the regime, this leaves the protection of Russian investment or French investment unaffected. Next slide. Then we have to move to another issue, which is perhaps core to the discussion. Is the modification otherwise incompatible with the ECT? More specifically, is it not that the ECT grants irrevocable rights to investors? Is it not so that investment law is about granting individual rights to investors? And is it possible to modify such rights without the agreement of the right holders, the investors? First, this depends on the contracting state's intent. And second, it is important to see that the Vienna Convention on the Law of Treaties, where the rights of third states are concerned, provides that third parties' rights are presumed to be revocable. So the rights granted to third parties by a treaty are presumed to be revocable without the agreement of the third party concerned. That is the first point. So it follows that unless the treaty otherwise provides, which it does not, the rights granted to third parties, to investors, can be revoked without their consent. And again, a further aspect is that it must be emphasized that investors' rights are not human rights, that they do not reflect the fundamental value of human dignity. They are not, how does one say, transcendental. The protection of individuals is, of course, an object of international investment law, but it is not its very purpose. Therefore, it is essentially distinct from human rights treaties, and therefore the fact that human rights treaties, individual human rights, which is well established, cannot be revoked by states, does not at all mean that investors' rights cannot be revoked by the state parties without the consent of the investors concerned. Next slide, I'm almost there. So the conclusion is, yes, you can modify the treaty. There is a possibility to change the ECT between some of the, I would say, able and willing contracting states only. It is important, given the very specific legal issues and the technical issues that arise, to specify, to explicitate the legal basis and the reasoning in the preamble. I think that is essential. It is important to specify the intention of the sovereign states that is at the basis of such modification, because that will guide arbitral tribunals that might be seized afterwards on such issues. And again, I would add, it is important to strictly limit the precedent so as to avoid any spilling over in situations where that would not be warranted. Thank you for your time and your attention. Thank you.
Thank you very much, Nicolas, for this very comprehensive overview about the possibility of modification through interstate agreements. I'm now turning to you, Nathalie. Could you perhaps tell us briefly your views on this approach and whether actually termination of or withdrawal could be better options, how that works, and it would be also great to hear from you in particular whether termination and withdrawal from investment treaties are something usual, and whether states experience and what are states and experiences and best practice in this regard.
Yeah, thank you very much, Amandine, and really thorough presentation by Nicolas. It's great, and it lays a really great foundation for the discussion later on, I think. I'd like to just build on Nicolas's intervention and would like to provide, as requested by Amandine, a bit of an overview of different approaches in investment treaties with respect to termination and withdrawal. So together we will briefly look at the termination of investment treaties under general public international law, as well as applicable termination and withdrawal clauses usually incorporated in investment treaties. Then we will look at the very unusual approach in investment treaties to extend the application of the treaty beyond its term through so-called survival clauses, and Nicolas, I think, usually refers to them as sunset clauses. And we will see that states increasingly actually do resort to termination and withdrawal of treaties, and they do this both unilaterally and mutually. And when done mutually, states increasingly amend survival clauses to neutralize them. So the first slide. The termination of investment treaties is actually a growing trend as more and more countries reevaluate their costs and benefits. An increasing number of countries are terminating and renegotiating old generation investment treaties. And in recent years, the number of effective terminations actually outpaced the number of new treaties signed. This trend to terminate old generation treaties that began less than a decade ago will likely intensify, we think, in the coming years with the increased awareness about the problems with investment treaties and investor-state dispute settlement, including with respect to the urgent climate action that is needed today and that Amandine referred to earlier. Next slide. We looked a little bit at how states were terminating their treaties and found that of all the bits terminated as of March this year, 47% were unilaterally terminated, 8% were jointly terminated without replacement of a new treaty, 42% were terminated with replacement of a new treaty, and 3% of the treaties simply expired. So when and how states can terminate or withdraw from a treaty, that will depend on customary international law and the treaty itself. So let's go to the next slide. Article 54 of the Vienna Convention on the Law of Treaties, we already have heard about it before from Nicolas. It provides that the termination of a treaty or the withdrawal of a party to a treaty may take place first in conformity with the provisions of the treaty, or at any time by consent of the parties after consultation with the other contracting state. If a state wants to terminate an investment treaty or withdraw from it, it has to do this in accordance with the termination provisions if they are available. And most investment treaties actually do contain such provisions, but they differ quite significantly. Article 54 also makes clear that if contracting parties agree to terminate, they can do so at any time. There are two main models for termination of clauses used in investment treaties. I'll briefly refer to them, but not in detail. One is the tacit renewal, or could be called tacit renewal termination clause, where a party can only terminate during a window of time until the treaty period of a certain number of years begins to run again. And the other is what could be called the fixed term termination clause, where after a period of a number of years, a party can terminate, but not before that. So most investment treaties follow one of these two models, and this is, of course, relevant for unilateral termination, while consensual termination can be done at any time. Next slide. I don't want to confuse you with those two approaches. And you can certainly read up on them. We've written about them. I don't want to confuse you and expand on it, because the ECT has a very different approach. The Energy Charter doesn't follow either of the two approaches, and in fact doesn't have a termination clause. Instead, it has a withdrawal clause that allows a contracting party to withdraw at any time. This withdrawal clause, like most investment treaties, is also includes, as you can see in paragraph 3, and you're surely all aware, a so-called survival clause. Survival clauses are unusual in the field of public international law. They are far-reaching because they allow for a treaty to continue producing legal effects after its termination or withdrawal. For the ECT, the duration is 20 years. So 20 years, as we all know, is a long time, and it is longer than the majority of investment treaties. And as we can see on the next slide briefly. Next slide. So here you can see that the majority of treaties have survival clauses of 10 years or some less even, but only a smaller portion, 16%, have 20 years survival clause. Next slide. Over the past 5 years, 6% or 21 cases out of 331 were initiated under a survival clause. As for the ECT, Italy, as you know, is so far the only treaty to have formally withdrawn from the treaty on the 1st of January 2016. And since then, 6 investor state claims have been initiated against Italy. Next. So we can see that survival clauses are being used, but whether a survival clause will actually bite, it depends on how the treaty was terminated or withdrawn from. We have seen cases brought and accepted by tribunals, both under treaties terminated unilaterally, of course, but also consensually. However, we have not to date seen any cases brought where the clause was previously neutralized by the parties. This may be a very good indication that neutralization can be effective or dissuasive, at least. And though some still argue that survival clauses cannot be neutralized, there is a wide agreement that they can, because contracting parties are the masters of their treaties, as we heard also from Nicolas, and should be able to override the survival clause by mutual consent. Nothing in the Vienna Convention speaks against this approach, and the law of treaties does not preclude neutralization. The argument allowed, or the argument by some that this is not possible because of the role or the rights of investors can be countered with the argument that any potential right of an investor under a treaty is subject to the party autonomy of states. And we've heard of further elaborations on this previously from Nicolas, and I also now want to give the floor or the screen back to Nicolas, who can expand a little bit on this particular issue. Thank you.
Thank you again. So if we move to the next slide, I think that a distinction must be made between the sunset clause or the survival clause, which raises issue of the law of treaties, and the distinct notion of acquired rights, which may be substantive and procedural. Next slide. As we've seen with Nathalie, the ECT contains a sunset clause, Article 47, which is subject to a number of conditions. First, of course, the treaty shall continue to apply to investments made, that is already made, before the withdrawal, which is, of course, an important element, because it means that as soon as one withdraws from the treaty, if you remember my risk assessment chart, you move away immediately from the deep red zone in the upper right corner, because protection is only due to investments that were made before. So there is an immediate advantage in withdrawal, the sunset clause notwithstanding. Investments made in the area of one investor and vice versa, as of the date when that contracting party's withdrawal from the treaty takes place for a period of 20 years. Next slide. This means that first, the sunset clause operates upon withdrawal, which means unilateral termination of the participation in the treaty. Now, there is further evidence that states can abolish termination clauses by agreement. It has nothing to do with sunset clauses. Some treaties provide that the treaty can be terminated, provided that a prior notice be given of 6 months or 1 year. Nobody ever doubted that such conditions on termination can be waived by mutual agreement between the contracting parties. The same applies to the sunset clause. The states are the masters of their treaty. There is, of course, that additional question, but is that compatible with the very object and purpose of the clause? So we must realize, and that is why at first, when I started considering this issue, or I discovered this debate, I was in fact slightly shocked by the idea that one might terminate the sunset clause, because of course the sunset clause aims at avoiding that an investor would enter the territory of another contracting party on Monday, having invested with the purpose of fructifying, gaining profits, making profits over the next 20 years, and then on Tuesday, the state would come by surprise and say, well, you know what, I have terminated treaty protection immediately. So this sounds bizarre, but as we will see, it is not. And it is important to note in the first place that investors, of course, can rely on treaty protection, but they must read the treaty clauses carefully. And when the treaty clause says that the sunset clause is triggered by withdrawal, they cannot count on the fact that the sunset clause will apply in case of termination by mutual agreement, because that is simply not a guarantee that is given even by the very terms of the treaty. But let us look further into the requirements of investor and investment protection. Next slide. Is investor treaty protection revocable? I have discussed this issue already. You will remember that I indicated that under the Vienna Convention on the Law of Treaties, Rights granted to third parties are presumed to be revocable without their consent. Second, there are some sources to the effect that investors' rights are direct rights granted to them, but there are also sources to the effect that they are derivative, as Nathalie said, meaning that they in fact belong to the state, entering into the treaty, and where the choice has to be made between direct or derivative, again, it is important to remind that investors' rights are not human rights. While it is stated by the Human Rights Committee that, for example, the covenants on civil and political rights cannot be terminated, that human rights devolve with the territory, because they reflect the basic cornerstone of international law, human dignity. The ECT can be terminated. The states can terminate the treaty, albeit with a sunset clause, and therefore it is well established by the ECT itself that the rights of the investors at some point in time are in the hands of the states. Otherwise, they could not be terminated, as would be the case for human rights treaties. And there is therefore room for states entering into a new treaty to express the authentic interpretation of the contracting states on such issues. They are, as contracting parties, in a position to say, we, the masters of the treaties, consider that the investors' rights are derivative rights and that we can dispose of them at least in certain conditions. Next slide. Now, what are the conditions? The conditions, I think, are not an issue of treaty law, they are an issue of acquired rights. That is what is of concern to us. Are we not violating the acquired rights of foreign investors? And then the first point is there an acquired right to the prolongation of a treaty regime as such? The answer is no. There are only acquired rights for special titles of acquisition for specific rights. Next slide. Are there acquired rights triggered by violations of the treaty? That is arguable. I will not enter into the details, but it is arguable that once a violation has been committed, it comes within the purview of the treaty, and therefore the investor whose rights have been violated is entitled to treaty protection. Of course, if that is the issue, then the protection is far more limited, again, than under the sunset clause that has been abolished. It is only that a state cannot withdraw protection with respect to violations already committed. Next slide. And the other issue is acquired rights from a procedural perspective. Are there acquired rights that can be triggered by an arbitration agreement? The state and the investor have actually entered into an arbitration agreement. Well, yes, if the agreement has been concluded, at least in my view, there is no way the states can annul recourse to arbitration under an accepted arbitration agreement. Or at least there is an acquired right. And again, a fortiori, if the tribunal has already been seized, there is, in my view, no way a treaty modification could withdraw the case from the tribunal that has actually been seized of the case. Next slide. But you can see, of course, that these are very limited situations as compared to the overall broad application of the sunset clause. That is one. And the second point, the last point, is that acquired rights do not benefit from absolute protection. There are no acquired rights incapable of change. Even acquired rights can be changed subject to a proportionality test. And so even where it is considered that the change comes into conflict with an acquired right, that does not mean that the right must be respected in its entirety. Thank you very much. Next slide. The next slide, I can be brief. It's the same as the previous one. Yes, you can yes, you can terminate the sunset clause. It is important to specify what you are doing. It is important to limit precedent. Thank you very much.
Thank you, Nicolas, and thank you, Nathalie, both for your very thorough overview of termination, withdrawal, the sunset clause, and how the legal effects can actually be mitigated and neutralized through an inter se agreement. I think we will come back later on this issue, but I would like to give the floor now to Professor Matthew Happold. Matthew, in the ACMEA ruling, the Court of Justice of the European Union ruled that ISDS in intra-EU bilateral investment treaties is not compatible with EU law. We have seen recently the Advocate General confirming this reasoning applies also to the ECT. We know that Belgium has requested also an opinion to the Court of Justice on this matter. And there is also another preliminary questions from the Svea Court of Appeal in Sweden that is pending on this question. So I think it would be very valuable to have an overview of what is happening with all these rulings, what could be the implications, and how are they going to affect the modernization process?
Thank you very much, Amandine. I will endeavour to be brief, which will be easier because I think in many respects, Nathalie and Nicolas have already said a number of things that I was going to say, probably rather better than I was going to say. But in any case, although I think we may disagree on parts of the reasoning, I think we agree with the results. So I've been asked to talk about what's going on in European law. If I can move to my first slide. The Energy Charter has already been mentioned. It's quite an old treaty. 26 of the member states are parties to it, Italy having withdrawn from the treaty with effect from the 1st of January 2016. But the European Union and Euratom are also contracting parties to the ECT, together with 22 third countries. So the ECT, the treaty, has a twofold characterization. On the one hand, it's a treaty, it's an international agreement. But on the other hand, as an international agreement concluded by the EU, it forms part of the EU legal order. It's binding on the EU institutions and the member states, but of course, in cases of conflict, the treaty prevails. And as already has been mentioned in recent years, claims, often intra-EU claims, have been brought under the ECT against a number of member states. Bulgaria, Germany, Italy, Poland, Romania, and Spain, as well as a claim against the EU itself by a Swiss corporation, which is ongoing. The arbitration is taking place under the Untitled arbitration rules with its seat in Toronto. Now, what was ACMEA all about? Apologies, many of you probably know this already. So I'll be reasonably brief. It concerned an intra-EU arbitration. It was an arbitration between a Dutch investor and Slovakia under the 1991 BIT between the Netherlands and the Czech and Slovak Federative Republic, to which Slovakia had succeeded to. Slovakia, of course, acceded to the European Union in 2004. The claim was made and the arbitration took place under the UNCITRAL rules with its seat in Frankfurt, Germany. Now, during the arbitral proceedings, Slovakia argued that the tribunal lacked jurisdiction because as a result of its accession to the EU, recourse to arbitration under the BIT was incompatible with EU law. After the tribunal ruled for the claimant, Slovakia sought to have the award side in the German courts, and as a consequence, the Bundesgerichtshof, the German Federal Court, requested a preliminary ruling from the European Court of Justice, asking whether Articles 267 and 344 of the Treaty on the Functioning of the European Union precluded the application of a BIT concluded prior to the date that one of the contracting states had acceded to the EU when the arbitral proceedings were brought under that date, after that date. And I've put down the court's conclusion. There's perhaps a couple of things that are worth saying about the judgment. It's a decision of the Grand Chamber of the Court. The Grand Chamber stressed that the terms of the applicable law clause of the BIT, Article 9(6), meant that a tribunal established under the BIT's investor-state dispute settlement provisions, Article 9, might be called upon to apply, to interpret and apply EU law. And the Grand Chamber also distinguished between commercial arbitration and arbitration proceedings under the BIT. It said by concluding the BIT, the member state parties to it established a mechanism for settling disputes between an investor and a member state, which could prevent those disputes from being resolved in a manner that ensured the full effectiveness of EU law, even though they might concern the interpretation or application of that law. And similarly, the BIT differed from international agreements concluded by the EU, providing for the submission of disputes to a court created or designated by such agreements as regards the interpretation and application of their provision, provided that the autonomy of the EU and its legal orders is respected. So as I say on the PowerPoint, the Grand Chamber concluded that Articles 267 and 344, Treaty of the Functioning of the European Union, must be interpreted as precluding a provision in an international agreement concluded between member states, such as Article 8 of the Agreement on Encouragement and Reciprocal Protection of Investment between the Kingdom of the Netherlands and the Czech and Slovak Federative Republic, under which an investor from one of those member states may, in the event of a dispute concerning investments in the other member state, bring proceedings against the latter member state before an arbitral tribunal whose jurisdiction that member state has undertaken to accept. Now, what's important about the judgment is it's ex tunc from the outset, and it's not ex nunc from now on. Nothing about there's nothing in it specifically about when incompatibility might have begun, but the implication is that it must be applied to all intra-EU BITs. The stress in the judgment is that the crucial date is accession to the Union. And given that Articles 216 and 344 had been provisions of the treaty establishing the European community, and the 2020 intra-EU BIT termination agreement certainly evidences that understanding. Final thing to say about the decision is it says nothing about the compatibility of the substantive provisions of BITs with EU law. That's a matter for another day. Perhaps we can have the next slide. So it's ACMEA was about a BAT. It wasn't about the Energy Charter Treaty. And the fairly immediate consequence, however, less than a year later, we get declarations of the member states on the legal consequences of the judgment of the Court of Justice in ACMEA and on investment protection in the European Union. I won't go through these, but you get one declaration by most of the member states. I think it's 22 member states, which inter alia said international agreements concluded by the Union, including the Energy Charter Treaty, are an integral part of the EU legal order and must therefore be compatible with the treaties. Arbitral tribunals interpret the Energy Charter Treaty as also containing an investor-state arbitration clause between member states, interpreted in such a manner that clause would be incompatible with the treaties and would thus have to be disapplied. So 22 of the member states state that they think that ACMEA, the reasoning in ACMEA, applies to the Energy Charter Treaty, as well as, at least in its in the application, the intra-EU application of its dispute settlement provision, Article 26, as well as to intra-EU BITs. But then we get two separate declarations made the next day, one by Finland, Luxembourg, Malta, Slovenia, and Sweden, and one by Hungary. And both of those say, well, it's too early to express any view as to the compatibility of EU law with EU law of the intra-EU application of the ECT. So an attempt by them, I think, to avoid the question for reasons that I think is frankly rather apparent when you look at the pending intra-EU arbitrations under the ECT at the time. If I have the next slide. Now, while this is all going on, it has to be said that arbitral tribunals are proceeding merrily on their way, paying very little attention to ACMEA. In intra-EU claims brought under the ECT, respondent member states make the arguments of the incompatibility of Article 26 of the ECT with EU law, and they're uniformly rejected. Perhaps the most sophisticated, and I think the longest response to this was by the arbitral tribunal in Escasol against Italy. It's a decision just after, some months after the member states' declarations. And of course, it's a decision taken after the had withdrawn from the ECT, although I think the claim was made just prior to Italy's withdrawal becoming effective. And the tribunal in that case purported to interpret ACMEA to say that because the ECT contains no equivalent incorporation into its applicable law of either category that the Court of Justice found offending in Article 8.6, it should be 9.6, I think, of the ACMEA BIT. The Court of Justice is concerned about a tribunal applying EU law under the ACMEA BIT is not directly transposable to the ECT. So in other words, they attempted to distinguish ACMEA to say that it only applied to a specific type of BIT or BITs with a specific type of applicable law provisions that required the tribunals established under the BIT to apply national law and to apply relevant applicable treaties. And that is not the case with the Energy Charter Treaty. So in the tribunal's opinion, EU law wasn't applicable law for ECT tribunals because it doesn't fall within the category of applicable rules and principles of international law, which is what ECT tribunals have to apply together with the treaty. And on that basis, the tribunal said that the danger to the integrity of the EU legal order perceived by the Court of Justice in ACMEA simply didn't resist as regards arbitration under the ECT. Now, I think that's highly debatable. It's certainly, of course, not what most of the member states thought. We can see that in their 2015, not 2019 declaration. And I think that if you look at opinion 117 on the and what the full court said on what needed to exclude EU law as applicable law under CETA, then I think that may not be right either. So that there are various reasons, I think, for thinking that is wrong even on its terms. And I think strong reasons to think it's wrong as a matter of EU law. If I have my next slide. So then finally, I don't think I need to say anything about the response to ACMEA by the member states was to May 2020 agreement on the termination of BITs between member states. I don't need to say anything about it really, because although the agreement has entered into force, I think 13 member states have either ratified it or declared they will provisionally apply. I think Spain did that. If you read the preamble, you find that it does not cover intra-EU proceedings on the basis of Article 26 of the Energy Charter Treaty. The EU and its member states will deal with this matter as a later stage. So the matter has been kicked down the road. Problem is the matter going to stay down the road? And that's what my next slide will tell us. So at the end of last year, we got a Belgium. Belgium announced that it was making a request for an opinion on the intra-EU application of the Energy Charter Treaty. Now, quite what those provisions might be, I suppose, formally speaking, we don't know yet. The negotiations aren't concluded, but it looks like they're not going to change in any substantive way or at all. The press release, I haven't seen, I don't think it's in the official journal yet, I may be wrong. The press release said that Belgium's seeking legal clarification from the court on the compatibility under union law of the dispute settlement mechanism provided for in the draft Modernised Energy Charter Treaty, in view of the fact that this mechanism could be interpreted as allowing its application intra-EU. Now, Belgium says that it's not taking any position on this, but I think, frankly, that making the request is taking a position, because it's asking for the court to determine the matter. It's asking the court to, and what that means is, can no longer engage in, I think, creative ambiguity on the matter. If I have my next slide, we'll find that it's not actually the only potentially relevant case that's before the ECJ. There are, in fact, 3 other cases coming down the road as well. The first one, I'm not going to read its full name because I know I've got limited time, but it's 2 cases that have been referred from the administrative court for a preliminary. It's a reference for a preliminary reading from, I think, the administrative court in Lazio in Italy. It concerns domestic proceedings before the Italian courts, where Italian investors, it's a renewables case, so many of these are, where investors claimed that they benefit from the provisions, Article 10 of the Energy Charter Treaty, as EU law. Now, we haven't had a judgment case yet, but we have had an opinion of the Advocate General towards the end of last year. Plainly, the Energy Charter doesn't apply because there's not a diversity of nationality between the investors and the respondent state. And that's what he said, but he also went on to suggest, or rather obiter, that the Article 26 of the ECT, the Investor State Dispute Settlement Provision, is not applicable to intra-EU disputes. So the court, in that case, would have the opportunity to take up that matter. It doesn't have to, but it could. And it's the same in the second case, Moldova v. Comstroy, another request for a preliminary ruling, this time from the Cour d'appel de Paris. There we have a new Energy Charter Treaty arbitration. The arbitration was in Paris, so it was subject to the supervision of the French courts, and an award having been rendered, it was challenged, and the Cour d'appel has asked for a preliminary ruling on what certain provisions of how certain provisions of the Energy Charter should be interpreted. Now, again, the court doesn't have to rule on the intra-EU applicability of the Investor State Dispute Settlement Provision of the Energy Charter Treaty. But in the opinion of the Advocate General, which came out only this month, he made the same suggestion that's already been made, that Article 26 of the ECT is not applicable to intra-EU. And he also raised the issue of whether the substantive provisions of the ECT were compatible with EU law. Now, again, the court doesn't need to rule on that matter, but I think it at least needs to be considered, because when there was the oral hearing in the case, the court asked whether representatives of the member states wished to be heard on the matter, and a number of them were. And I would say that gives us some indication as to the court thing. Finally, there's the case mentioned by Ahmadine on the Republic of PL Holdings. That's another request for preliminary ruling, this time from the Svea Court of Appeal in Sweden. But I think I've probably said enough on those cases. I was told over 4 minutes ago that I had 4 minutes left. I am as eager as everyone else to engage in discussion on these matters. I did have a couple of slides which looked at provisions of the ECT. I think I need to go through them now.
Yes.
I think Nicola and Natalie have said what I would say on them. So thank you. I'll end there.
Thank you, Matthew. Thank you, all of you, for sharing your opinions on those very difficult legal questions. That was very interesting. Before we opened the floor for question and answer, I just wanted to get back to Natalie just for closing questions. Because we've been discussing on the withdrawal and the sunset clause. And I wanted to hear from you, from a climate perspective and sustainable development perspective, if you have really to assess the risks, how much the risks do you think that are big from the withdrawal and the sunset clause, and are these risks so big that it makes it safer to stay into the ECT? I think it would be really interesting to hear from you what you think.
Thanks, Amandine. That's an interesting question. I think I would like to really pick up on what Nicola started with. So I think there are a lot of risks in every option, or let's say not. Well, there are risks, but also mitigation of risks for each option to some extent. And for sure, what is very difficult is to predict anything, in my view. So we can give very strong legal arguments, and I think Nicholas just presented some, but we ultimately don't know what a tribunal will do or say. And that is just as much the case, in my view, for actually amending the rules. And I'm not talking about modification, but the ongoing modernization negotiations. Those, even if, let's say, there was a conclusion, there would still be a lot of uncertainty because everything depends on the interpretation of these tribunals. And I don't think there is another area of law that is as unpredictable, because you have a body of law in the treaties, but it's applied in so many different ways depending on the combination of arbitrators sitting on a case. So it's very hard to say this is a greater risk compared to another. Certainly, we don't know what a substantive outcome would be, so that would depend on that. But even let's assume we had a very good outcome, it wouldn't be risk-free. As soon as you have investor-state arbitration, it's not risk-free. But most likely, as we heard, it will be very hard to get the countries and the states on the same page, and to have a significant outcome, an acceptable outcome for everyone from a climate perspective, sustainable development perspective, but also just the legal perspective from the modernization of investment law as such. We think that the parties are in such different places that it's unclear whether probably not possible to get a really good outcome there. So then that leaves us with other options. We heard about modification. We didn't talk so much about interpretation. And then there's termination. And I think that the risk for terminating, withdrawing, let's say, is no greater than any of the other options. At least, you know, you do, if you can even combine it with an agreement between the EU member states to neutralize the survival clause between themselves, that would even further mitigate the risk. So, but ultimately, there's no precedent. We don't know the outcome, but it's certainly a very important avenue to investigate very thoroughly.